And welcome back. Will Worsham joins us now for this week's Speaking Legal discussion. Good to see you again.
Good to be here as always.
All right, are you ready for this one?
Yeah, let's
All right, here we go. What are the implications of signing a non-compete agreement? Are these legal if they essentially keep you from earning a living, especially if you are let go from your company?
First of all, what is a non-compete?
Yeah.
Describe what that is.
Sure, a non-compete agreement is just an agreement that you have with an employer or partners or a business you've been a part of that says, if I'm no longer a part of this business, no longer in your employee, I promise that I won't compete with your business. So I won't go to work for competitors. I won't start a new business that competes. It's a non-compete. I promise not to compete.
That's not generally a forever thing, though.
No, no, no. In fact, non-compete agreements are disfavored instruments under the law, so they're very tightly scrutinized.
What does disfavor?
It just means as a public policy, we don't like them.
Oh, okay.
We recognize that there are certain circumstances that they're appropriate and necessary, but as a general rule, we don't like them for exactly the reason stated in the question. They prevent you from earning a living in your chosen trained field. So all non-compete agreements, when they come under the scrutiny of a court, which means somebody's trying to enforce one, are going to have to be determined to be reasonable in both time and space. Now, that's not as Star Trek-y as it sounds.
Yeah.
It means it has to be for a reasonable amount of time. It can't be like forever, like you said. It can't be for the rest of your life. You can never do this thing. And typically, I've never really seen one, and I haven't seen them all, but normally you're usually talking about 2 to 5 years. Generally is what you'll see written into a lot of agreements, and that generally means that that's been deemed to be a reasonable restriction on someone's right to engage in their free exercise of their employment. And they also be reasonable in space. So like if the business that you are leaving works only in Springfield and not outside of the Springfield radius, it's not reasonable for that non-compete to say you can't do this anywhere in the United States.
Right.
So as long as because if you're in St. Louis, you're probably not competing with them in Springfield.
Right.
So they have to be reasonable in time and space in order to be enforceable.
Now, okay, this is assuming that everything is, you know, following by the letter and everything. What about if you are laid off or fired or anything like that?
Yeah,
Sure.
I hire you, now I fire you,
Right.
but you can't go to work for anybody for a couple of years.
Right.
Now that's a problem.
And so people often will sign no-compete agreements without giving a lot of thought to it, but they are contracts, just like anything else. And contracts are enforceable by their terms if they're reasonable. Right? So if there's a reasonable non-compete that says, even if you're laid off, if it just talks about separation from the company, it is enforceable even if they fire you, because that was the agreement. Because you got consideration. You traded, they got a non-compete from you, and you got something from them. You got a job.
Right.
And sometimes I've seen companies will come in and they'll want their current employees to sign a non-compete. Really, in order for that to be enforceable, there has to be some consideration on the other side of that contract. So
now you're adding something.
Now you're adding. So sometimes companies will say, so we're going to give you a raise, but it's contingent upon you signing this. It has gone to court and it has been decided that consideration for a non-compete can be your continued employment, i.e. if you don't sign this, we're going to fire you. And so in exchange for your continued employment, you have to sign this non-compete agreement.
So if you have something like that put in front of you, it would behoove you to have someone with a legal eye take a look at it before you sign off.
Yeah, just to make sure
you
understand, because they can have a lot of different clauses to them. A lot of them have liquidated damages clauses, which mean, you know, we don't know if you violate this agreement what kind of damages it's really going to incur, and it's going to be difficult to prove. So we're just going to agree up front that it's $100 a day. For every day that you compete, that you're in violation of the agreement, you're going to owe us $100 or $1,000 or whatever the contract says. That also has to be reasonable.
Yeah, but don't make the mistake of thinking because they end your employment, that has ended that agreement.
Not necessarily.
All right.
That may be something you could have written in there.
It could be.
Because you don't want me anymore, then
I would assume.
don't.
Yeah, if you fire me, then I'm out of my no-compete.
Then what do you care what I do?
And it could be negotiated as part of a severance package as well.
Okay, interesting. Boy, have somebody look at it first. Okay, if you have a legal question for Will, email him at wworship@color10.com. He'll answer your question on the show. And up next, the man with the mind for money is here.
Yep, Mr. Bruce Porter joins us right after this.
Be right back.